Stay with me, because what unfolded inside that federal courtroom today wasn't just another routine hearing. It was a moment that changed the tone of the entire case, a moment that sent a message not just to the defendant, not just to the legal teams, but to every political figure, every strategist, and every observer watching from across the country. Early this morning, the courtroom doors opened under a level of security rarely seen outside the most sensitive national cases. The atmosphere was tense, controlled, and unusually quiet. Lawyers whispered instead of spoke. Staff members moved quickly but cautiously. Even veteran reporters, used to high-stakes proceedings, seemed to sense that something different was about to happen. And then the judge entered. What followed was not a long speech, not a theatrical moment, not a dramatic gavel strike. It was something far more powerful. Calm, procedural, and unmistakably firm, the judge issued a single directive that changed the entire trajectory of the case. Immediate enforcement. Those two words carried more weight than any argument presented that morning. They meant the court had reached a threshold. They meant patience had run out. They meant that the courtroom was no longer a place for negotiation or delay. It had become a place of action. Within moments, federal marshals moved into position, not aggressively, not theatrically, but decisively. Their presence wasn't symbolic. It wasn't about intimidation or optics. It was about control. It was about compliance. It was about ensuring that every order issued by the court would be followed without delay, without exception, and without negotiation. And that is where the reality of the situation became clear. Because when a federal judge orders immediate enforcement, it signals more than urgency. It signals that the court believes the stakes are high enough to require direct, physical assurance of compliance. It means the legal system is no longer operating on trust or assumption. It is operating on enforcement. Inside the courtroom, the shift was immediate. Conversations stopped, movement slowed, every eye turned toward the bench and then toward the marshals. The defendant, once confident and composed, now faced a very different reality. The legal battle was no longer theoretical, it was operational. From a procedural standpoint, this kind of move is rare, but not unprecedented. Federal judges have the authority to enforce their orders directly, especially when they believe there is a risk of interference, non-compliance, or obstruction. But invoking that authority in a high-profile political case sends a message far beyond the courtroom walls. It tells the public that the court is serious. It tells the legal teams that delay tactics will not work. And it tells the defendant that the rules have changed. Because once enforcement begins, every action is monitored, every movement is documented, every decision carries immediate consequences. The courtroom becomes more than a venue for arguments. It becomes a controlled environment where compliance is not optional, it is required. For the defense, this creates an entirely new strategic landscape. Previously, the legal approach may have relied on timing, public messaging, and procedural maneuvering. Motions could be filed, hearings could be delayed, statements could be made outside the courtroom to influence perception. But enforcement changes everything. When marshals are present under direct judicial order, the margin for error disappears. The defense must now operate under strict scrutiny. Every communication, every public comment, every legal move must be measured against the risk of violating court directives. Even small missteps can carry large consequences, and that reality creates pressure. Not just legal pressure, but psychological pressure, because the defendant is no longer operating in an environment where influence or reputation can shape outcomes. They are operating in a system governed by procedure, authority, and enforcement. Inside the legal teams, the tone shifts. Advisors become cautious, lawyers become precise, public relations strategies are reevaluated. Every word is chosen carefully. Every appearance is planned with legal implications in mind. This is the moment when a case stops being about narrative and starts being about compliance. And for high-profile defendants, that shift can be profound. Because influence, connections, and media presence mean very little inside a courtroom where enforcement has been activated. The judge controls the schedule, the court controls the movement, and the marshals ensure that those orders are carried out. Historically, moments like this mark a turning point. Not necessarily the end of a case, but the end of a certain kind of strategy, the end of delay, the end of ambiguity, the end of the assumption that the process can be stretched or negotiated. Instead, the case enters a new phase, a phase where the timeline becomes rigid, a phase where compliance is monitored, a phase where every step forward is enforced, not suggested. And that is exactly what unfolded today. The judge's order didn't just affect the defendant. It sent shockwaves through the entire legal operation surrounding the case. Lawyers immediately began recalculating their next moves. Advisors adjusted their messaging. Political allies started reconsidering their public positions, because when enforcement begins, the stakes become real in a way they weren't before. This is no longer about what might happen months down the line. It is about what is happening right now inside a courtroom where authority is no longer theoretical. It is active, it is present, and it is being enforced. The next hearings, the next filings, the next public statements, every one of them will now take place under the shadow of that order. Immediate enforcement. Two words that transformed the tone of the entire case, two words that turned a courtroom into a controlled environment, and two words that signaled to everyone watching that the legal system had entered a new phase, one defined not by speculation, but by action. The moment enforcement begins, the atmosphere around a case changes in ways that are both immediate and irreversible. What once felt like a long, drawn-out legal battle suddenly becomes a tightly controlled process where the margin for maneuvering shrinks with every passing hour. Inside the defense team, the shift is almost palpable. Phones that once rang constantly with political advisors, media consultants, and outside strategists now carry a different tone. Conversations become shorter, more cautious. Lawyers speak in measured language. Every instruction is double-checked. Every statement is reviewed, because enforcement changes the rules of engagement. Before the judge's order, the defense still had options that relied on time. Motions could be filed to delay proceedings. Public statements could shape perception. Allies could rally behind the defendant, creating a sense of momentum or pressure. But now the courtroom is operating under direct judicial control. And that control is physical, visible, and immediate. The presence of federal marshals is not just symbolic. It sends a clear message. The court expects compliance, and it is prepared to ensure it. For the defense, that means the old playbook no longer works. There is no room for theatrical gestures, no space for dramatic public confrontations, no tolerance for last-minute attempts to reshape the narrative. Every move must now be calculated within the strict boundaries set by the court, and those boundaries are not flexible. Inside the legal team's strategy meetings, the tone becomes serious, almost surgical. Instead of discussing media angles or political reactions, the conversation turns to risk management. What statements could trigger further enforcement? What actions might be interpreted as obstruction? What communications must now be restricted or supervised? These are the kinds of questions that begin to dominate the room. Because once enforcement begins, the court is no longer just observing the case. It is actively controlling the environment in which the case unfolds. That means the defense must operate under constant awareness of the court's authority. Every decision carries immediate consequences. Even something as simple as a public comment can now be interpreted through the lens of compliance. If the court believes a statement could influence witnesses, interfere with evidence, or undermine proceedings, it has the authority to act. And under an enforcement order, that authority is not theoretical. It is operational. For the defendant, the psychological impact of this shift can be profound. The courtroom is no longer just a stage for legal arguments. It becomes a controlled space where movements are monitored, interactions are regulated, and the boundaries of freedom are clearly defined. Every entrance and exit is observed. Every conversation is measured. Every action carries the weight of potential consequences. This kind of environment creates pressure, not just on the defendant, but on everyone connected to the case. Family members become cautious about communication. Political allies reconsider public statements. Advisors begin to distance themselves from any action that could be interpreted as interference. The ripple effect spreads quickly, because enforcement doesn't just affect the person at the center of the case, it affects the entire network around them. Lawyers, strategists, and political figures all begin to adjust their behavior. They understand that the court is watching closely, and that any misstep could trigger additional orders, stricter controls, or even new charges. This is the moment when the legal system asserts its authority in a way that cannot be ignored. The defense can no longer rely on influence, connections, or public pressure. Those tools lose their effectiveness inside a courtroom governed by enforcement. Instead, the focus shifts to compliance. How to follow the court's orders precisely, how to avoid triggering additional scrutiny, how to navigate a process where every move is documented and enforceable. For seasoned legal teams, this kind of shift is familiar, but still unsettling. It marks the transition from a strategic battle to a controlled process. The case is no longer about shaping the timeline. It is about surviving it. And that survival depends on strict adherence to the court's directives. Meanwhile, outside the courtroom, the political landscape begins to react. Allies who once spoke confidently about the defendant's chances start to sound more cautious. Public statements become less aggressive, more measured. The tone shifts from certainty to concern because enforcement sends a signal. It tells observers that the court sees real risk. It suggests that the judge believes the situation requires more than routine oversight. And in high-profile cases, that perception alone can reshape public opinion. Political operatives begin to calculate the cost of association. Media strategists adjust their messaging. Donors, supporters, and allies all start asking the same question. What does this enforcement order really mean? And the answer is simple but powerful. It means the court is in control, not the media, not the political parties, not the public narrative, the court. Inside the legal system, this kind of moment often marks a turning point. Cases that once felt uncertain begin to take on a more defined trajectory. The timeline becomes clearer, the boundaries become stricter, the consequences become more immediate. And for the defense, the realization sets in. The strategy they planned weeks or months ago may no longer apply. They must adapt quickly, carefully, and with full awareness that the court is now enforcing its authority in real time. This is the phase where legal battles become intensely procedural. Every filing, every hearing, every motion is scrutinized not just for its legal merit, but for its compliance with the court's orders. There is no room for improvisation, no tolerance for risk, no space for theatrics, only procedure, only compliance, only the steady, controlled movement of a case under direct judicial authority. And as the next hearing approaches, one thing is clear. The courtroom is no longer a place where strategies can be stretched or narratives can be manipulated. It has become a place of enforcement, precision, and accountability. The defense knows it, the political world senses it, and the defendant feels it. The rules have changed, and there is no going back. And two words that signaled to everyone watching that the legal system had entered a new phase, one defined not by speculation, but by action. By the time the news of the enforcement order spreads beyond the courthouse steps, the legal story begins to transform into a political one. What started as a procedural move inside a federal courtroom quickly becomes a national conversation, reshaping alliances, strategies, and public messaging across the political landscape. Within hours, advisors, party officials, and strategists begin reassessing their positions. In the world of politics, perception can be as powerful as reality. And the perception of enforcement, of marshals present, of judicial authority actively asserted, carries enormous weight. It signals seriousness, it signals urgency, and perhaps most importantly, it signals that the court believes the situation demands immediate control. For political allies, this creates a difficult calculation. Public loyalty has always been a cornerstone of political survival. Standing by a powerful figure, especially one with a strong base of support, can offer protection, influence, and opportunity. But when legal enforcement enters the picture, the equation changes. Suddenly, loyalty comes with risk. Every public statement becomes a potential liability. Every appearance alongside the defendant carries new implications. Every tweet, interview, or endorsement must be weighed against the reality that the case is no longer just a legal matter. It is now a controlled, enforced process under direct judicial authority. Inside party offices and campaign war rooms, conversations grow more serious. Strategists pull up polling data. Communications teams draft alternative messaging plans. Senior advisors begin to ask difficult questions about timing, optics, and long-term consequences. Is public support still an asset, or has it become a liability? In competitive districts and swing regions, the stakes are especially high. Candidates who once proudly aligned themselves with the defendant now face a different political environment. Voters who might have ignored legal controversies before may now pay closer attention when enforcement becomes visible. Because enforcement feels real. It is not an investigation that may or may not lead somewhere. It is not a rumor or a leak or a speculative report. It is a concrete action taken by a court, carried out by federal authorities, and visible to the public. And that visibility changes everything. Party leaders must now balance two competing forces: loyalty to a powerful figure and responsibility to the broader political coalition. Too much distance, and they risk alienating the base. Too much support, and they risk being tied to a case that is entering a more serious phase. It is a delicate balance, one that requires careful messaging, disciplined communication, and constant recalibration. Meanwhile, media coverage intensifies. News panels analyze the meaning of enforcement orders. Legal experts debate the implications. Political commentators speculate about how the case could affect upcoming elections, party unity, and national strategy. The narrative begins to shift. Instead of focusing on allegations or arguments, the conversation centers on authority, on the judge's decision, on the visible presence of enforcement, on the message it sends about the seriousness of the case. And that message resonates beyond the courtroom. International observers take note as well. When a high-profile political figure faces direct judicial enforcement, it becomes more than a domestic legal story. It becomes a signal about institutional strength, political stability, and the functioning of the legal system. Allies watch to see whether the system holds. Adversaries watch for signs of weakness or division. Financial markets, diplomatic circles, and international media outlets all begin to analyze the situation through a broader lens. The case is no longer just about one defendant or one courtroom. It has become a symbol of how institutions respond under pressure. Back inside the political sphere, the reactions continue to evolve. Some allies double down on their support, framing the enforcement as overreach or political targeting. Others grow quieter, choosing their words carefully, avoiding direct confrontation with the court's authority. And a third group begins to distance themselves entirely, not dramatically, not publicly, but subtly. Fewer appearances, shorter statements, less direct association, because in politics, survival often depends on timing. And many leaders recognize that enforcement marks a turning point, not just legally, but politically. It is the moment when a controversy becomes a crisis. For the defendant, this shift is deeply personal. The political network that once provided strength and reassurance now feels less certain. Allies who once spoke with confidence now sound cautious. Support that once felt unconditional now comes with conditions. And that isolation can be just as powerful as any legal pressure, because high-profile figures often rely on their political ecosystems as much as their legal teams. When that ecosystem begins to shift, when loyalty becomes conditional, when support becomes strategic, the psychological impact is significant. Inside the courtroom, the enforcement continues. Schedules are enforced precisely. Movements are monitored. Communications are scrutinized. The process moves forward step by step under the direct authority of the court. There is no room for delay, no space for improvisation, no tolerance for interference. And as the next hearing approaches, both the legal and political worlds understand the reality of the situation. The case has entered a new phase, a phase defined not by speculation, but by enforcement. A phase where political calculations must adapt to legal realities. A phase where the courtroom, not the campaign trail, sets the pace. And as the pressure builds, one question begins to dominate conversations across the country. What happens next? Because in moments like this, history often turns not on dramatic speeches or public rallies, but on quiet procedural decisions made inside a courtroom, decisions that carry consequences far beyond its walls. And two words that signaled to everyone watching that the legal system had entered a new phase, one defined not by speculation, but by action.